A very good morning to you all. On behalf of Dr.M.G.R Educational Research Institute and the Department of Information Technology, I'm Rameshwaran, Assistant Professor. I delight to welcome you all to the Virtual Faculty Development Program on Intellectual Property Rights and Patents. For past 3 days, we gathered here an understanding of the significant topics. Today, we are in the fourth day. We are going to see about the patent filling and prosecution by our chief guest speaker, Dr. Lipika Patnaik, Senior Principal Scientist, CSIR, IPU, New Delhi. Now, I invite Professor Dr. Dalia Sam to deliver the welcome address.
And good morning, everyone. It is my pleasure to welcome you all for this fourth day of our faculty development program on intellectual property rights and patents. Over the past few days, we have delved deeply into various aspects of IPR and patents. We have gained valuable insights from all our esteemed speakers. Today, we are privileged to continue this journey with another exceptional speaker. She'll be speaking on patent filing and prosecution. I would like to extend a warm welcome to our distinguished speaker, Dr. Lipika Patnaik, Senior Principal Scientist at CSIR, IPU, New Delhi. Dr. Patnaik brings with her a wealth of knowledge and extensive experience in the field of intellectual property rights. Her expertise will undoubtedly provide us with deeper understanding of the intricacies involved in patent filing as well as the prosecution process. I would also like to extend my heartfelt thanks to our President Engineer ACS Shanmugam sir for his unwavering support and encouragement. A special welcome to our Head of the Department, Dr. N. Kanya, whose presence and leadership has been vital in guiding and enhancing the quality of this FDP. I also express my gratitude to the coordinators of this FDP, Mrs. Madhura and Mrs. Vishwapriya, whose dedication and meticulous planning has been instrumental in making this program a resounding success. I would also like to welcome all our fellow faculty members and all the participants whose enthusiasm and commitment to learning has made this program a true success. As we prepare to embark on today's session, I encourage all the participants to actively engage, ask your questions in the chat box, and make the best use of this opportunity to learn from one of the experts in this field. Thank you, and let's make this session a productive and enlightening one.
Thank you so much, Dr. Dalia, for your warm welcome address. Before we proceed with Chief Guest address, I would like to invite Mr. T. Vijayarasu, Assistant Professor, the Department of IT, to introduce our esteemed Chief Guest, Speaker Dr. Lipika Patnaik.
I am professionally overjoyed to take this opportunity to introduce our Chief Guest, Dr. Lipika Patnaik. She is a PhD in Life Science and holds an LLB degree. She is presently working as a Principal Scientist in the Innovation Protection Unit of Council of Scientific and Industry Research. Before joining CSIR, she was worked in Indian Patent Office for more than 12 years, both as an examiner and controller of patent and design. She has also worked as an examiner of Indian Patent Office as ISA and IPA. During her period at Indian Patent Office, she has been actively involved on preparation of guidelines for examination of patent application in the field of pharmaceuticals, guidelines for examination of biotechnology application for the patent, and guidelines for processing of patents application relating to traditional knowledge and biological material. A present profile at CSIR involves securing, protecting, and managing the intellectual property of CSIR. She is actively involved in handling issues related to Biological Diversity Act 2024 and Biological Diversity Rules 2004 of India and dealing with the National Biodiversity Authorities of India, with administrative the biodiversity law. She is also involved in vetting of IP clauses and forming opinion of IP issues in agreements, MOUs, proposals, and license agreement concerning contract R&D projects and consultations. She is also involved in reviewing and managing of IP portfolio of CSA. Thank you.
Thank you so much, Mr. Vijayarasu, for the wonderful introduction. As we embark on this journey of exploration and learning, we eagerly anticipate our chief guest for his valuable insights and wisdoms of today's topic, patent filling in prosecution. Please join me in extending a warm welcome, Dr. Lipika Patnaik. She graces us with her esteemed presence and delivers an invaluable speech. Welcome.
Thank you very much. Thank you for this nice introduction, sir. So, I believe this is the fourth day of this faculty development program. And first of all, I am audible, right?
Yes, ma'am, you're audible. Audible.
Okay. So this is the fourth day of the faculty development program, and I believe you are now aware of what are the intellectual property rights like copyright, trademarks, patents, designs, and all. And in this session, we'll be discussing about basically patent filing and prosecution. It means what all are required for filing a patent application, specifically in India, and what all are required during the patent prosecution to get a grant of a patent. So let's start with, let me share my presentation. So hope my presentation is visible and it is in slideshow mode. So in case it is not visible or not in slideshow mode, please inform, otherwise I am proceeding, right?
Visible,
So
ma'am. Your slide is visible.
In this session, we'll be discussing about patent filing. We will discuss who can be the applicant. It means who can file a patent application in India, where it is to be filed. It has a jurisdictional requirement. So in which patent office it is to be filed, what are the different patent filing routes, what are the documents required for filing patent application in India, the different types of patent application, different types of specification, requirement of publication and request for examination in the Indian patent system. And then we'll discuss about patent prosecution, basically formal and technical examination, and what are the essentials of the patent that are required to be fulfilled for grant of a patent, and very briefly about the opposition system existing in the Indian patent system. So to start with, intellectual property right, as you all know, are exclusive rights granted to the creator of such IP for its commercial exploitation, and which is subjected to national laws and international agreement, and it is given with a view to reward the intellectual creativity of that person. And patents are one of the most important form of intellectual property right, the strongest form of intellectual property right. It is an exclusive territorial right granted by the government to the inventor or his assignee for an invention. And what are the rights conferred? Rights are to exclude other from making, using, selling, offering for sale, or importing the invention into India for a limited period of 20 years, and it is given against the disclosure of the invention given in the patent specification. So it is it's a bargain, like you will get a monopoly or grant on a patent, and against that grant you will be disclosing your invention to the government, to the public. You will be given exclusivity of 20 years, and after that, if the invention is in public domain, anyone can use your invention. So patents in India are administered by the Patent Act 1970 and Patent Rules 2003. It says, as I said, it is a territorial right for 20 years. It is granted by the government for invention which are new, inventive, industrially applicable products or processes. So this slide shows the different stages the patent application moves from the date of filing to its grant or refusal. So once the application is filed, if it is filed with a provisional specification, I'll come to the specification in my subsequent slides, but just to understand the system, if it is filed with a provisional specification, the complete is required to be filed within 12 months. And once the complete is filed, after completion of 18 months, till 18 months, the patent application is a secret document. After 18 months, it is published by the Indian Patent Office, and it is now open for pre-grant opposition. And next phase is examination, but examination is not automatic, it has to be requested, and the request for examination is required to be filed within 31 months from the date of filing or priority. This period was 48 months previously, and the rules has been amended very recently in 2024, and this period has been reduced from 48 months to 31 months. So request for examination is to be filed within this particular period, and once the request for examination is filed, the application is forwarded to the examination division, and the controller examiner having expertise in that particular field examines your application. and the examiner conducts prior art searches, and he reports to the controller that what are his observations, and the controller conveys the gist of the observations as the examination report to the applicant. The first such report is called the first examination report, or FER. Once such report is received, applicant is supposed to reply to this report within 6 months, which is extendable by 3 and plus 3 months after paying fee. And once the reply is submitted, it is again examined by the patent office, and if it is considered satisfactory to the controller, the patent is granted. If it is not considered satisfactory, the controller gives the applicant an opportunity of being heard. So a hearing notice is issued. And once a hearing notice is issued, the applicant is given another opportunity to amend the claim, amend the specification, and if it is satisfactory to the controller, the case is granted. If not, the case is refused. And the decision of the patent office is challengeable or appealable at the High Court. And if the patent is granted, so in case a pre-grant opposition is filed, the pre-grant opposition could be filed at any time after the publication till the grant of a patent. So if the pre-grant opposition is filed, the grounds of pre-grant opposition and grounds of normal examination are mixed, and the decision is taken to grant or refusal simultaneously. And after the patent is granted and the grant is published, it is open for post-grant opposition for a period of 1 year. And in case any post-grant opposition is received, it is decided by opposition board and the hearing controller, and it is decided after that. So this is basically how the patent application moves from filing to grant. Now, the first important and most important question is, who can file an application? It means who can be the applicant. Of course, the true and first inventor could be the applicant. So when I'm saying true and first inventor, it means a person who has actually invented. So it is a natural person. The person who has imported the invention from outside India, or the person to whom the invention is communicated from outside India, is not considered the true and first inventor. It is a natural person who has actually invented, or it is a group of natural persons who has actually invented. So they can be the applicant as well as inventor while filing the patent application. Other than the true and first inventor, the assignee of the true and first inventor could also be the applicant. So when I'm saying assignee could be another natural person or a legal entity. Legal entities could be startups, small entities, educational institutions like yours, and large entities as well. So this natural person, small entities, startups, and educational institution enjoy relaxation in official fee, filing fee, whatever fee is to be paid to the patent office, they enjoy relaxation in that. But it means large entities has to pay the entire fee. Now, other than these two, the legal representative or the legal hire of a deceased person who was entitled to file a patent application before his death could also file a patent application, and patent application could be filed alone or jointly. It means 2 or more natural persons could be applicant, 2 or more legal entities could be applicant. Natural person along with legal entities could also become applicant of a patent application in India. So where it is to be filed? So I think you all may be knowing we have 4 IP offices, 4 patent offices in India, each representing the region of India. And how it is decided in which office it is to be filed? It is decided by the applicants or the first mentioned applicant's residence, domicile, place of business, or where the invention has been originated. And in case of a foreign applicant, he has to have an address of service in India, and the location of address of service in India decides in which patent office the application is to be filed. But it is very important and critical, because if the application is filed in a patent office that is not having jurisdiction on that case, though the patent system of now the patent office are linked and it is centralized, most of the things are centralized, but this jurisdictional requirement are the provisions of the Act. So if this requirement is not met, the application will not be taken further. So the care should be taken at this point as well. Next is to see what are the different patent filing routes. Basically, there are 2 routes. Traditional route and PCT route. And under traditional route, the types of applications that are filed are ordinary, conventional, divisional application, and patent of adhesion. I'll come to these applications and where and when such applications are to be filed. I'll describe in my subsequent slides. And under the PCT route, PCT international application and PCT national phase applications are filed. I'll also discuss that, but let us first see what are the important documents required for filing patent application. First and foremost is the application form. It is provided in Form 1. So Form 1 is basically a document where I'm linking to Form 1. I hope the Form 1 is visible to you. This is through a hyperlink, so I hope the form 1 is visible to you. So basically, in form 1, the applicant details, it means if it is what type of application it is. It means if it is an ordinary, conventional, PCT national phase application, divisional, or patent of addition, that has to be disclosed. And then the applicant details, its name, nationality, address, everything has to be disclosed. And then what type of person it is, if it is a small startup, small entity, educational institution, that has to be mentioned. And then who are the inventors of the case, that is required to be mentioned, and their details are required to be mentioned. Then the title of invention is required to be mentioned here. In case it is application is being dealt by a patent agent, then the agent details are required to be mentioned here. And the address of service, it means in which address the patent office will communicate. It will serve it notice, serve any communication is required to be mentioned here. And in case it is a conventional application, priority details. If it is a PCT application details. If it is a divisional or patent of addition, the first application details are required to be mentioned. You will know what are these when I'll move to those the types of application. But further, in form 1, the applicant has to declare whether a biological material from India is being used in this invention, and of course, what are the number of pages in the specification, what are the number of claims in the specification, what are the number of drawing sheets, and what is the amount of fee that is to be paid is to be mentioned, and of course, it has to be signed and dated. So, okay, now this is the first application, form 1. So next important document is proof of right. Proof of right means in case the inventor is not the applicant. So the inventor has to assign his invention to the applicant, and the applicant should have the proof of right to file the patent application. So this assignment is the proof of right. So it is generally provided in 2 ways. The application form 1 could be endorsed by all the inventors saying that they have assigned their invention to the applicant, and in a separate deed of assignment could also be filed. Next important document is the specification. Application in India could be filed with provisional or complete specification, particularly ordinary applications. And if application is filed with a provisional, complete has to be filed within 12 months. So this specification, this is the form of the specification. The title of invention has to be provided. Applicant details are required to be provided. If it is a provisional specification, it has to be mentioned whether it is a provisional or a complete. Then if it is a provisional specification, description of the invention is to be provided, but claims are not required. If it is a complete specification, the description is to be provided in details and claims are required to be provided, and it has to be signed and dated, and the abstract of the invention should also be provided. So these are the basic requirement while filing form 2 or specification. Next important document is the statement and undertaking providing foreign filing details. It means in this document, the applicant gives an statement that in which all other jurisdiction, it means in which all other countries, the same or substantially same patent application has already been filed. And he also undertakes to inform the controller about any subsequent filing within the time provided under the specific rule. So this is the format of form 3. In form 3, the applicant details are required to be provided, and then in this table, in which country the patent application is already filed, the date of filing, the application number, what is the status of that application, whether it is published or not, and whether it is like granted, refused, or if it is not disposed, then the status of that application is required to be mentioned, and of course it has to be signed and dated by the applicant. And the next important document is a priority document. So the requirement of priority document arises in case of conventional application. It means those applications claiming priority of a previous application. I'll discuss about this conventional application in my subsequent slide, but for this slide's sake, understand that conventional application needs the priority document to be filed because it is claiming the priority of a previous application. So and the next important document is the declaration of inventors. It is filed on form 5, and it must be filed in case application is filed with a provisional and subsequently complete specification is being filed, or it is a conventional application, or it is a PCT national phase application. In that case, Form 5 is required to be filed. So let's see what Form 5 say requires. So it requires the name of applicant and name of all the inventor, their details, and of course a signature of that applicant. And in case of convention country, details that who are the applicant there and who is the applicant here. Then their signature is also required to be provided. So basically, in this document, the applicant declares that who are the actual inventors of the invention from which the applicant has derived the title, or the applicant has proof of right to file the application. Okay, next is power of authority. In case the patent application is being dealt by a patent agent or attorney, and in that case, power of authority in favor of that patent agent is required to be filed on Form 26, and of course a fee has to be paid. In case you want to know the fees, all the fees for filing and different stages or different requirement or fees that are required with different forms, you can refer to the Schedule 1 of the Patent Act or Patent Rules, and you can see this particular table where you can see what is the amount of fee that is required to be filed in case you are a natural person, small entity, educational institution, and the number of pages is within 30, claims within 10, then only 1600 is required to be filed. If you are a large entity, then 8000 is required to be filed. Similarly, it is fees for all possible activities with the patent office. All possible forms are provided in the schedule, in that particular schedule. So now let's move forward to what are the different types of application. Under the traditional route, the first and foremost application that is required to be discussed is ordinary application. Ordinary application means that application that doesn't have any priority. Everything commences from the date of filing of this application. And let's see what are the documents that are required. First of all, application form 1 is required. In case the inventor is not the application, the proof of right is required. In this case, both provisional and complete specifications could be filed on Form 2. So in other cases, provisional could not be filed. And in case the application is being dealt by a patent agent, a power of authority in favor of that patent agent is required to be filed, and foreign filing details are required to be provided on Form 3, and of course the fee has to be paid. These are the basic minimum requirements that are to be filed with that are to be fulfilled when an ordinary application is being filed. And coming to conventional application, conventional application are those applications that claim priority of a previous application. So I think you all must be knowing India is a party to the Paris Convention, and one of the most important principle of Paris Convention is the principle of priority. It means one national of any Paris Convention state can file one patent application in any Paris Convention country, and he can claim the priority of that application and can file a subsequent application in any other Paris Convention country, and he can claim the priority of that application. And what is the benefit? Benefit is that any document that is published within this 12 months period will not be considered prior act for his subsequent application, because he is claiming the priority of his basic application, which is filed in another Paris Convention country. So of course, it does the conventional application is to be filed within 12 months from the priority application. There may be multiple priorities, but the 12 months is calculated from the first priority, and each claim has its own priority. In the subsequent application, there may be a number of claims, and each claim has its own priority depending upon in which priority application the subject matter is disclosed. Now let's see what are the additional documents required in this case. First of all, the application form 1 should mention the priority details in the priority application number, date, and all. And it has to be filed with a complete specification. Provisional could not be filed. Third requirement, it has to be filed with a declaration of inventorship on Form 5. It is mandatory. And a proof of right in case the inventor is not the applicant, or the applicant in the convention country or the first country is not the applicant in India. In that case, a proof of right is required to be filed. And of course, it is claiming a priority, so a priority document is required to be filed. It means if priority document is the first application that is filed in the first country. So entire specification is filed, of course, provided as a priority document in the second country. So in this case, if it is not in Indian official language, translation of the same is also required to be filed. Now coming to the divisional application. In case the applicant has already filed a patent application, And he got to know that there are more than one inventions in it. Or the patent office says that, look, in your patent application there are more than one invention. So what can be done? The application could be divided out. The first application is considered the parent application, and all the divided out applications are considered the divisional application. So the divisional application should be filed before the grant of the main application, and the entire set of the specifications should be exactly the same, but the claim sets are different because they pertain to different invention which are divided out from the main one. And the parent application, the divisional application has the same priority as that of the parent application. Now coming to the patent of addition. So let's say you have the patent applicant has already filed a patent application, and there is a further improvement or modification over it. So what he can do? So in this condition, he knows that, and he want to protect this improvement as well. And he knows that if he file another application, it may not be considered inventive. It may be considered novel, because novelty and inventive steps are requirement for grant of a patent. So if it is considered, it may be considered novel because it is a modification, but it might not be considered inventive because depending upon his own first application. So what he can do? He can file a patent of addition. So patent of addition is to be filed after filing of the main application at any time of this 20 years period. So, for example, if the main application is filed and after 15 years there is a modification to that, then the patent of addition could be filed after 15 years, but the term of the patent of addition is coterminous with the main application. It means it has only 5-year lifetime, because the patent has only 20 years lifetime. And the patent, and here important thing to mention here is the patent of addition will not be granted unless the patent is granted and it is granted for the equal term, as I said. But no renewal fee is also required. It is basically considered the same application. The renewal fee means once the patent is granted, it is granted for 20 years, but you have to pay renewal fee to maintain it for 20 years. It will be maintained only if you go on paying the renewal fee. So in this case, if the renewal fee for the parent is going, or the main application is being filed or given to the patent office, then renewal fee for the patent of addition is not required. But if the first application is lapsed, abandoned, or something like, you do not continue that, but in that case, the applicant has to pay the renewal fee for the rest of the term for the patent of addition. And here I want to mention that this parent application or main application could be an ordinary application or a conventional application or even a PCT national phase application. So these are the applications which are filed through traditional route. Now coming to the PCT route. PCT means the Patent Cooperation Treaty, and India became a signatory to this treaty in 7th December 1998. And it is not a granting system, it is a unified filing system. So basically what was happening before this system, once the patent application is filed, let's say a Paris Convention country national has filed one application in one country, and he wants to claim the priority and file in 5 countries. So what he has to do then? He has to first hire 5 attorneys in 5 countries. He has to prepare 5 set of specifications which may require translation according to their official language, and he has to pay 5 set of fees and in these countries, and he has to file all these applications within 12 months, which was actually a very huge task and very impossible task to do. And so so this PCT system was adopted. In this case, the applicant can file one application in the receiving office of PCT. All the IP offices of all the Paris Convention countries are the receiving office of PCT. So he can file one application at the receiving office of PCT, and at the time of filing, he has to designate 2-3 things. First of all, he has to select an international searching authority and an international preliminary examination authority, and he has to designate the states or the countries in which he wants the patent application to be protected in future. So after this being done, this filing is construed as if he has filed in all those designated countries. He may not enter into those countries, but it will be construed as if his ways are open to enter those countries in the national phase, and his filing date will be protected with him. So once the application is filed, it is forwarded to the searching authority, and the searching authority establishes an international search report, ISA, and a written opinion. So based on the written opinion and international search report, the applicant can decide in which country he wants to enter in the national phase. And there are 2 optional stages as well. In case the applicant wants his application to be searched by another searching authority having expertise in that particular field. For example, his invention involves some traditional knowledge or something based on Chinese medicine. So he wants it to be searched by the Chinese patent office as well. So he can opt for a supplementary international search. So it will again be searched by the Chinese office according to their databases, which may be in Chinese language, which the first searching authority, which may be India, they may not understand or might not be having. So such a provision is also be there. And in case the search report is so negative and the applicant wants to amend his application, he can amend under Article 34 of the PCT, and he can opt for or demand for international preliminary examination. So what is that? The International Preliminary Examination Authority examines his amended application, and they establish an international preliminary examination report. And now based on this report, the applicant can move into national phases. So after the completion of 30 months in most of the countries, 20 months in few countries, and 31 months in few countries, the application enters into the national phase. And it is again examined by the national IP offices, and then the patent is granted or refused according to their law. So in India, it is 31 months. Once a PCT application or PCT national application is filed, it will be considered for examination after the completion of 31 months from the date of filing or priority, whichever is earlier. So India being the receiving office of PCT, Indian Patent Office being the receiving office of PCT, receives PCT international application, and Indian Patent Office being the national IP office receives the national phase applications as well. Okay, now the filing is done. Next is what happens then? Then the patent office publishes the application. Till 18 months, the application is a secret document, and after 18 months it is published. Ordinary applications are published after 18 months from the date of filing. Conventional applications are published after 18 months from the date of priority, because it is claiming a priority. Application on which secrecy direction is imposed, they are examined after 18 months from the date of filing of priority, or when the secrecy direction is revoked. Divisional application and patent of additions are published after the completion of priority, if 18 months from the date of priority of the parent application, or immediately after the filing of the divisional or patent of addition. PCT national phase applications are published immediately, because in the PCT, I forgot to mention, in the PCT there is a stage where it is called the international publication. So after 18 months, the PCT application is published by the International Bureau, which is situated at Geneva. So because this is already published, so this PCT national phase application is published immediately after filing. And the applicant can also request for early publication. If he wants, he will not be waiting for 18 months. He has to pay some fee and get his application published on, and the request is on Form 9. And if this request is filed, the application is published within 1 month. So what are not published? If an applicant has filed one application with a provisional and complete is not filed, the application will not be published. If the application is filed and the applicant himself wants to withdraw his application, and it has to be done within 15 months, because after 15 months the process for preparation for publication starts. So it has to be withdrawn within 15 months. So such applications are also not published. And what are published? Basically, what is the application, applicant and inventor names and details, what is the abstract, what is the technical field, what is the IPC, it means what is the international patent classification under which this application is falling. So all these are published. And what is the effect of publication? Actually, publication determines certain fact of the case. Till that date, it is a secret document. No one can claim, no one can go to court, it is a secret document. But after it is published, it becomes who is the applicant, the priority date, who is the applicant, who are the inventor, what is the field of technology. So everything is published. Now it is in public domain. Then the invention become a prior art for every subsequent application that is filed. So, and this publication also opens the door for commercialization. So the industry who is working on this particular thing can come to the applicant and to get a license of their invention. And it also discourages competitors. Those who are working in that particular field, they get dissuaded when your patent application is published, because the liability of infringement accrue from that date. It means you can send a notice to that infringer or the competitor saying that, look, my patent application is published. But you cannot sue that person because your patent is not yet granted. But when your patent is granted, you can sue that person and claim royalty from him from the date of publication till the date of your suit is decided. Next is once the application is published, it opens the door for pre-grant opposition. So anyone can oppose the grant of your patent on certain grounds, and the entire application is now open for inspection. So previously, inspection was a very important thing. People go to patent office to inspect files, but nowadays everything is now open in the patent office databases. Once the application is published, you can see every document that is filed by the applicant in the patent office database, in past database. Next is the examination, but here examination is also not automatic. It has to be requested. Section 11b says that an application shall not be examined, or no application shall be examined unless the applicant or an interested person requests for its examination within 31 months from the date of filing or priority, whichever is earlier. This period was previously 48 months. Now it is 31 months by the recent amendment. And if no such request is received, then it is considered that the application is withdrawn by the applicant. So application is not automatic. It has to be requested. Request has to be done on Form 18 or 18A, and by applicant or third party, and the examination report is given to the applicant. So 18A is basically a form in which normal request for examination is filed. So this is Form 18A. So in 18A, the normal request for examination is filed, the application number, and you have to mention what is the application number, and you request the patent office to examine the application. Or express request for examination could also be filed. It means in case your application is a PCT national phase application and you want it to be examined before 31 months, so you have to give an express request for examination on Form 18. Or in case on Form 18A, a request for expedited examination could be filed. There is an opportunity to get your application examined much before that. Generally, the application are arranged in queue according to the request for examination. So if the expedited request for examination is there, it is removed from the queue and allotted immediately to the examiner controller to examine the application. So it is available to government organization, natural person, women applicants, small startups, small entities, or those applicant who has chosen India as the searching authority or preliminary examination authority. So it is given to certain type of applicants. Now let's move forward to understand what are the types of specification that could be filed. In India, application could be filed with provisional or complete specification, basically ordinary applications. So when you file a provisional specification, it is filed to secure the early filing date, and it should comprise the description of the invention. The specification should have some description of the invention, and claims are not required in the provisional specification. But the specification should, the point to remember here is specification should describe the invention, and the description should be written. If someone is providing just a diagram or a drawing, that doesn't suffice the requirement. And because the benefit of this early filing could be availed when the subject matter of the claim, which is going to be filed in the complete specification in a later date, is actually disclosed in the first application, in the provisional application. So if, for example, if you are disclosing, in the provisional application, a compound A is disclosed, and in the complete specification there is claim on compound A, compound B, and a composition of A plus B. In that case, the claim on compound A will enjoy this early filing date, but the compound B and A plus B will not have this early filing date. It means anything that is published within this particular period could become a prior art for that particular claim, but claim on A will enjoy the filing date. So while filing provisional specification, try to disclose as much as possible. Second is the complete specification. So complete specification could be filed directly with an application, or if a provisional is filed, complete has to be filed within 12 months. And the complete specification should describe the entire invention with working example, and it should contain the claims. So the claims are the most important part of the specification, and the patent office examines the complete specification. Next is the complete. Let's see what are the parts of the complete specification very briefly. So it should commence with a title, and title should be indicative of the subject. It should be brief and relevant to the subject matter, and it should be within 15 words. Then it should follow by the field of invention. In this part, the applicant should provide what are the broad general field, technical field, and what is the specific field to which the invention relates. Other than that, nothing is required to be mentioned there. And it has to be followed by a background of invention. Background of invention means what is the general state of art focusing on a particular problem, and what are the documents or patent application journal articles that is trying to solve that problem, and references of those documents. For patent application, you can mention the patent application number or patent publication number, but for journal articles, you have to mention the entire reference. The citation of that has to be mentioned, and what these documents are describing. And in this, after that, the applicant should mention that what are the drawbacks in these documents, which he has already mentioned in the previous part. And then he should establish the need of his invention. It means he should be in a position to say that his invention is overcoming the drawbacks of the prior art. So this has to be mentioned in the background of invention. Next is the summary. Summary is the entire outline of the invention. It should cover all the subject matter of all the independent claims, all the dependent claims, all the alternative embodiments are to be provided in the summary of invention. And whatever are mentioned, what are the aspects, features which are mentioned in the summary are to be described in details in the detailed description of the invention. So detailed description is a very important part of the specification next to the claims. So in detailed description, one should mention every part of the specification in details. For example, if your claim invention is let's say is a product or apparatus, every part of the apparatus or every part of that product, how they fit with each other and how they are interrelated with each other and how they work with each other is required to be described. In case your claim invention is a process, what is the starting material? What are the intermediate steps? What are the intermediates being produced? And what is the final product? And what are the parameters to carry out the process? What are the reagent, what are the solvent systems that are required? Everything has to be provided. Next, in case your claimed invention is a compound, what is the structure of the compound? What is its chemical formula, character, molecular weight, size, everything? How it is produced, starting from starting material, intermediates, final product, how it is produced. The entire process is to be provided. And how to characterize it, how you understand, how you know that this particular compound has this particular structure, how the identification of the compound, its characterization, everything has to be provided. And of course, the utility of the compound is also required to be provided. A compound is being claimed for some utility, so its use is also required to be mentioned in the detailed description with working examples. If it is treating a disease, biological assay data are to be provided in the specification and working examples to show that this compound is actually working. And finally, the detailed description should be written in such a way that it fits into all the alternative embodiment. When I'm saying embodiment, it means in case the claim is there is a product which is produced by 3 processes. All the 3 processes, each of these 3 processes are the alternative embodiments of the invention. So all the 3 processes should be provided, and it should be provided in such a manner that the person who will be working the invention or carrying out the invention could at least carry out one embodiment of the invention to reach at the final product. So detailed description has to be so much descriptive. Now, next part is the claims. Claims are the most important part of the patent specification because it determines the scope of protection you get or the patentee gets once the patent is granted. So it should be very carefully, very diligently and tactfully drafted. And of course, it should be accompanied by an abstract, which is a summary of the invention in 150 words, and drawings if mandatory. It is not mandatory, but if it is required to understand the invention or if the controller wants it, then drawing is required to be provided. Basically, you should understand the specification is a techno-legal document. It should describe all the technical aspects of the invention, and it should be described in such a manner that the legal requirement of the patent law is fulfilled. And both the technical and legal requirement are important for the grant of patent. So when I am saying technical requirement, in case the claimed invention is a product, the specification should describe the product, its functioning, its process for preparation of the product, process for using the product. These are the technical aspects of the invention. But The product should fulfill the requirement of patent law, that is, it should be novel, it should be inventive, it should be industrially applicable, it should not fall within non-patentable inventions in India, and it should, whatever is being claimed should be sufficiently disclosed. These are the legal requirement, and everything is required in the complete specification because it is a techno-legal document. So by now, your application is already filed. So next is examination. In examination, basically two types of examination happens in the patent prosecution: formality examination and technical examination. When I am saying formality examination, it means if the application is filed in proper jurisdiction or not, what are the forms required, whether they are properly filled or not, foreign filing information is provided or not, proof of right is there or not, declaration of inventorship is provided or not, power of authority, fees are properly paid or not, timeline requirement, the jurisdiction requirement, and translation if required. All these things are checked and communicated to the applicant in the first examination report. And next, the second type of examination that is done is the technical or substantive examination. So in this, it is checked whether the claimed invention is novel, inventive, and industrially applicable. And it is so if these things are fulfilled, it qualifies as an invention. But if it falls within the provision of section 3 and 4, it will not be considered patentable invention. And whatever is being claimed should be very sufficiently described in the specification. And this is also checked, and requirement of unity is also checked. It means whether all the claims of the invention are linked by a single inventive concept or not. So basically, if the inventive feature is common in all the claims, then it is considered it is considered that the invention has unity. So in the prosecution stage, for grant of a patent, there are some technical requirements each patent must fulfill. And let's see what the Patent Act first provides for that. First and foremost, and I'd like to refer to section 21J. 21J defines invention. It says invention means a new product or process involving inventive step and capable of industrial application. So it has to be new, novel, inventive, and industrially applicable. So if these three things are there, it is an invention. Section 21JA defines inventive step. It says it means it's a feature of invention that involves technical advancement, economic significance, or both, and that makes the invention not obvious to a person's clear. So it has to be technically advanced, economic significant, or both, and it should be non-obvious. Then in section 21AC defines capable of industrial application. It means the invention is capable of being made or used by the industry. So if these three requirements are fulfilled, as I said, the subject matter of the claim qualifies as an invention, but it will still not be considered patentable in India if it falls within the provision of section 3 and 4. So section 3 and 4 are basically a list of things that are not patentable in India. I'll come to these in my subsequent slides. And the next important requirement is sufficiency of disclosure. It means whatever is being claimed should be very sufficiently disclosed in the patent specification. So when I'm saying novelty and inventive step, it means something is novel against what? Novel against something existing. So the patent office has to find out what are the existing document or existing prior art document or anticipating prior art document from which the invention could be anticipated. So section 13 provides for this. It says that the examiner shall make investigation to ascertain whether the subject matter of the claimed invention is anticipated by publication in a patent application filed in India after 1st January 1912. So it basically covers prior patent publication in India. Section 13(1)(b) says that the claimed invention, subject matter of the claimed invention is claimed in a patent application which may not be published, but that is claiming a priority that is earlier to the priority of the application which is being examined. So it basically covers prior claiming in India. And section 13(2) says that the examiner shall also make investigation to ascertain whether the claimed invention has been anticipated by publication in India or elsewhere in the world in any document that is not covered under section 13(1). So it basically covers every patent publication outside India, every non-patent publication in India, outside India. So section 13 is a very comprehensive section. It covers everything that could be considered as a prior art or anticipating prior art. But there are some exceptions as well. Section 29 to 34 provides for exception from anticipation. So if the prior art document falls within these, then it will not be considered as an anticipating prior art. So let's see very briefly what these are. Section 29 provides for exception from anticipation by previous publication. It says that if the subject matter of the invention is published in a patent application that is filed in India before 1st January 1912, it will not be considered as a prior art document. Second, it says that if the subject matter is of the invention is obtained from the true and first inventor and published without his consent, then it will also be not considered, and the application is filed as soon as this fact is known to the applicant, then it will not be also be considered as a prior art document. But the onus of proving this, that it has been obtained from the true and first inventor wrongfully and published without his consent, is the onus is on the applicant to prove. Next is exception from anticipation by communication to the government. If the subject matter of the invention is communicated to the government to determine its merit, such a communication will, if it is prior to the application, it will not be considered an anticipating prior art. Section 31 says exception from anticipation by public display. If the subject matter of the invention has been displayed in an exhibition which is notified by the government for that purpose, or there is a subsequent publication or use of the invention after such a display in the exhibition, or the subject matter of the invention is read by the true and first inventor before a learned society, or it is published in transaction of such society. In that case, and the application is filed within 12 months of such display, use, or publication. In that case, these things will not be considered as anticipating prior art. So I want to focus on this point because here the scientific community are generally very interested in publishing their things. So this provision is already existing in the Patent Act, but there was no prescribed rules or the procedure laid to how to implement this. So decisions were very subjective depending upon the controller who is dealing the case. But now there is a clear-cut rule and clear-cut form for this. So you can claim a grace period of 12 months. So if you have published somewhere, you can mention that I am the true and first inventor. I have published my invention in that publication, and I am claiming for a grace period of 12 months, which is provided under section 31. So in this case, this is a very new development in the recent amendment. Moving forward, section 32 says that in case the invention is of such nature that it could not be worked in secret, or trial has to be done in public. So in that case, if there is a public working and this is for the trial of the invention, then it will also not be considered as an anticipating prior art. And further, it also says that section 33 says that if provisional is filed and then it is subsequently used or published, then it will not be considered as a prior art document. And of course, these exceptions are only applicable when the circumstances of 29 to 32 are there. In case that no exceptions could be provided for anticipation other than these conditions. So basically, whatever is there in the written, there in a public domain, it is written somewhere, disclosed somewhere orally, it is being used somewhere, it is there in the internet, it is there in the book, everything comprises the state of art. It means prior art. So, but these are to be used again in case of determining novelty and inventive step. So when novelty is being determined, only one prior art document is compared at a time. But when inventive step is determined, combining prior art documents are allowable. We'll see how it happens. So first step during examination is determining novelty of a claim. So how it is to be determined? Determining novelty is comparatively simpler. So the claimed invention is to be compared with a prior art document. In case there is some difference, then claimed invention is novel. So how it is to be done? First step is to evaluate what are the elements of the claim invention. Second step is to assess whether every element of the claim invention is explicitly or inherently disclosed in any particular prior art document. So if it is disclosed, claim invention lacks novelty. So the disclosure may be explicit, it means it should be written directly, or inherent, it means it is inherently present. Then also those documents would be cited for novelty purpose. And here I want to mention that novelty of each claim is judged independently by the patent office. For example, claim 1 is a composition of A plus B. Claim 2 is a composition of claim 1 further comprising C. So if there is a prior art document that discloses A plus B, then it is novelty destroying for claim 1. It will not be considered novelty destroying for claim 2. Now, as I mentioned earlier, we have talked about explicit disclosure. It means anything that is directly written. But Sometimes there are some implicit disclosure in the prior art, or something implied from the prior art, teaching of the prior art, or there are some inherent thing in the prior art which is not expressly written. Those things could be also be considered during novelty determination. For example, you should keep in mind that everything in case of a patent thing, the prior art is also read with the eyes of a person skilled in that, who is skilled in that particular field. And if there is something implied in the prior art, or while carrying out the teaching of the prior art document, the person inevitably arrives at the claim invention. In that case, that prior art would be cited for novelty purpose. In case there is some inherent anticipation, it means something is missing in the prior art, not written, but the person skilled in that knows that it is inherently present. So that document could also be cited. For example, if prior art discloses or mention that it doesn't explicitly says that rubber is an elastic material, but it says that it says in scientific terms, it says elasticity property of rubber in Young's modulus and other scientific thing. In that case, and it is not saying that rubber is a elastic material expressly, but in case the claim invention is on an elastic material, then the prior art disclosing rubber could be cited there, because even though prior art disclosing rubber is not explicitly mentioning rubber is an elastic material, it is inherently saying that rubber is an elastic material. Now let's move forward to the to product by process claim. So products when claimed, they are claimed by its own characteristics, its own feature, its own components, its own compositions. But when the product is defined by the term in which it is prepared, by the terms of the process for preparation, it is called a product by process claim. So they are allowable only when they themselves fulfill the requirement of novelty and inventive steps. So they are judged or they are determined, interpreted in a very absolute sense, irrespective of the potential novelty of the process. For example, if the claim invention is compound C, which is obtained from a process X, and prior art discloses compound C, which is obtained from a process Y. Because this compound C is disclosed in this prior art, this claim will not be considered novel, even if it is produced by a novel process X. So care should be taken while drafting or writing product by process claim. Next important thing is combining document. As I have mentioned, combining documents are not allowable when novelty is being determined. But in case there is a primary prior art document that is explicitly referring to a secondary prior art document, then the teaching of the secondary prior art document is considered incorporated in the teaching of the primary prior art document, and that could be cited. For example, if the claimed invention is a process for preparing a compound, let's say C, and there are 4 steps, A, B, C, and D. Let's say the compound is X, and there are 4 steps, A, B, C, and D. And in the primary prior art document, it is also disclosing the process for preparing X, but the steps are A, B, C, and for the 4th step, it says that it has to be prepared as taught in another secondary prior art document, and the secondary prior art document teaches step D. So this teaching of this secondary prior art document will be incorporated in the teaching of the primary prior art document, and that primary prior art document could be cited for novelty purpose. Next question arises, what happens in case the claim invention is generic and prior art is specific, or the prior art is specific, claim invention is generic. Prior art is generic, claim invention is specific. In case the claim invention is generic, prior art is specific, the specific prior art destroys the novelty of a generic claim. In case the claim invention is specific, prior art is generic, the generic prior art cannot destroy the novelty of the specific claim. For example, if the claim invention is metal, prior art is copper, metal will not be considered novel over copper. If the claim invention is copper and prior art is metal, and copper is nowhere disclosed in the prior art, the claim over copper will be considered novel. Okay, now we understand how the patent office determines novelty. Next is determination of inventive step. As the definition says, there should be technical advancements, economic significance, or both, and it should not be obvious to a person skilled in that. So determining technical advancement, economic significance could be done by data, but this non-obviousness is something tricky, and some steps should be categorically followed to determine whether there is inventive step present or not, or whether it is non-obvious or not. So basically, every country has its own way of analyzing inventive step, but they are more or less the same. And the first step is to determine here is what is the inventive step of the thing. Second step is to determine who is the person skilled in that art. Third step is to determine what is the state of art, general skill in the art. So what is the prior art? Closest prior art. Fourth step is to determine whether there is difference between the inventive step and the state of art. And if there is a difference, the fifth step is to determine, without the knowledge of the claim invention, whether this difference constitutes steps that is obvious to a person skilled in that, or that requires some inventive contribution. So let us take an example to understand it. Here, the claimed invention is a compound of PYB3. This compound this is a pyrazole ring. It is attached to 3 ethyl groups, and this compound has analgesic property. And this is a prior art document, closes prior art. It discloses compound PYB3, but B stands for methyl group here, and this compound doesn't have any therapeutic property. So let us apply those steps here. First step is what is the inventive concept? Inventive concept is a pyrazole ring having 3 annular ethyl groups and the compound possessing analgesic property. This is the inventive concept. Second step is to know who is the person skilled in that. When I'm saying person skilled in that, it is not a normal person like you and me. It's an imaginary person. So imaginary person means he knows everything that is there in the internet. He knows everything that is there in any book. He knows everything in that field known in public domain. So in this case, a chemist could be a person skilled in that, or a team of organic chemists, pharmacologists could also be considered as a person skilled in that. And when the application is being examined, the examiner also steps into the shoes of a person skilled in that. So next step is to determine what is the state of art. So what is known to this person skilled in that? So organic chemistry of all the pyrazole compounds are known to the person skilled in that. All the compounds having analgesic property are known to the person skilled in that. So here, see, so this particular very close prior art is also known to the person skilled in that. So now next step is to determine whether there is a difference. Yes, there is a difference. 3 methyl groups are being replaced with 3 ethyl groups, and the compound is becoming therapeutically active. Now coming to the fifth step. Fifth step is to determine, without the knowledge of the claimed invention, whether this difference constitutes steps that is obvious or that requires some inventive contribution. So at this stage, from the teaching of the prior art document, there should be a reasonable expectation of success in trying something. So in this case, it may appear very easy to replace methyl with ethyl group to a organic chemist, but there is no reasonable expectation of success that such a replacement could make a compound which was not therapeutically active into a therapeutically active compound. So in this case, it will not be considered obvious and it will be considered inventive. So let's take another example to understand how combining documents are allowable. So in this claim invention, the claim invention is a process of preparation of galacto-oligosaccharide with high purity, and the steps are growing Bullera singularis microorganism and Saccharomyces species, immobilizing the microorganism, then hydrolyzing lactose with these immobilized microorganism, and optionally concentrating the galacto-oligosaccharide that is produced. Now we have 2 prior art documents. D1 discloses production of galacto-oligosaccharide by using immobilized Bullera singularis cell. It is not saying anything about Saccharomyces species. And D2 is saying that Saccharomyces species could also convert lactose to galacto-oligosaccharide, and it uses lactose as the carbon source and remove glucose from the system. So in this case, the claim invention, if compared to D1 and D2 individually, it will clearly be considered novel. But because when we come to inventive step, because D2 is clearly mentioning that Saccharomyces species could convert lactose to galacto-oligosaccharide, and it is also saying that it is removing glucose from the system, the person skilled in that with his general knowledge knows that glucose is a competitive inhibitor of beta-galactosidase enzyme which is responsible for this conversion. So in this case, he will be motivated to combine the teaching of D2 with D1, and he will arrive at the claim invention. So it will be considered obvious, not inventive. Now, what happens if the claimed invention is subgenus or species of a broad genus, in the prior art? So here, let's say this compound is a prior art compound, where this is a pyrazole ring, and there are 2 R groups, could be alkyl or aryl, and it is treating disease X. And let's come to the claim invention. Claim invention discloses a compound PY-R dash. This R dash is alkyl, let's say methyl ethyl. So whether this claim will be considered inventive or not. So first, one should keep in mind that if the prior art is providing you a list of variables, the prior art is motivating the person skilled in the art to choose from that list, to select from that list. So it will not be considered inventive. So it will be considered as a random selection. But if you are choosing from that variable but showing some property that is better not shown in the prior art document, for advantageous property, it will be considered inventive. But still, if the person skilled in the art knows that from these 10 variables, if I choose these two, I'll definitely get this advantageous property, then it will also not be considered inventive, or it will be considered obvious. Because let's take an example here. This compound, let's say it is a compound that is that is used to treat a central nervous system disorder. So this compound has to cross the blood brain barrier, and the smaller is the compound, the better advantageous effect could be achieved. So if from the variables provided in D1, a person skilled in that knows that if he select methyl and ethyl at the position of R1 instead of aryl or phenyl group, it will show better property as compared to aryl. So the person skilled in that knows that. So that's why it will be considered obvious, and this claim will not be considered inventive, even though advantageous property could be seen. Next is industrial applicability. So basically, as the definition says, invention is capable of being made or used by the industry. So it means whatever is being claimed must have some utility. So in case the para discloses some steroid compounds with some medicinal property, and in an applicant, the applicant has synthesized a list of the steroid compounds, but they doesn't show any activity, or he has not been able to demonstrate any activity in the specification. In that case, then it will not be considered industrially applicable, because there is no utility. Okay, by now we understand what is novelty, what is inventive step, and what is industrial applicability, and how to determine it. Next is, if all these three requirements are fulfilled, as I said, the claim subject matter will qualify as an invention, but it will not be considered patentable if it falls within the provision of section 3 and 4. I'll very briefly discuss about section 3 and 4. Section 3 says, if the claimed invention is something frivolous or against a well-established natural law, for example, a perpetual motion machine or a device that could give output without any input, so it is against a natural law, so it will not be considered patentable. Section 3b says primary intended or commercial exploitation of the invention if it is contrary to public order or morality, or is causes serious prejudice to human, animal, plant health, life, or environment, it will also be not considered patentable. So device for committing theft, burglary, human cloning are not patentable. Section 3c says scientific principle, abstract theory, or living and non-living substances occurring in nature. So Newton's law is not patentable. So Darwin's theory is not patentable. Discovery of living and non-living substance, animal, plant, microorganisms, metal, minerals from the earth crust, isolated sequences, polypeptide sequences, polynucleotide sequences occurring in nature are not patentable. Section 3D says that mere discovery of new form of known substance which doesn't result in enhancement of known efficacy of that substance, or mere discovery of a new property or new use of a known substance, or mere use of a known process machine apparatus, unless there is a new reactant or a new product is being produced, then it will not be considered patentable. So there is an explanation there. Salt, ether, ester, polymers, metabolites, all will be considered the same substance unless they differ significantly with regard to efficacy from the known substance. So if amorphous form of a compound is known, its polymorphic form or crystalline form will not be considered patentable. If a compound is known for treating disease X, claiming that compound for treating disease Y will not be considered patentable. Now coming to section 3e, it says that admixtures are not patentable. When you are combining something or the claim is a composition, the component must be synergistically acting with each other. It should not be just additive effect. So there must be something better than the individual properties of those. So and section 3f says mere arrangement, rearrangement, or duplication of known devices, each functioning independently of one another in a known way. So fitting a torch to a bucket or umbrella to a fan is not a patentable invention. Section 3h says agricultural methods are not patentable. Cultivation of algae, fungi, plant breeding, crossing, hybridization, pest control are agricultural methods. So they are not patentable in India because India is an agricultural country. Next, section 3i says process for medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, increase their economic value or of their products are not patentable. So treatment method on human being, removal of cancer, surgical procedures, vaccination method are not patentable. Detecting a particular marker to detect a particular disease is a diagnostic process, not patentable. Treating sheep to increase its wool, treating poultry to increase the body mass are not patentable because it is increasing the value of their products. And Section 3J says plant, animal, whole or part thereof are not patentable. Microorganisms are patentable, but this has to be read with Section 3C. Living substances occurring in nature are not patentable. So genetically modified microorganisms are only patentable in India. Plants, animal part are not patentable. Seeds, etc. are not patentable. Essential biological process for production and propagation of plants and animals are also not patentable. So propagation of plants, propagation of animals are not patentable. Mathematical business method computer programs are not patentable under Section 3K. And literary dramatic work are copyright protectable but not patentable. Scheme of performing mental act, playing games are not patentable. Presentation of information is not patentable. Topography of integrated circuits are not patentable. And invention which are in effect traditional knowledge or are aggregation or duplication of traditionally known components are also not patentable in India. So these are the list of things that are not patentable under Section 3. So now let's move forward to Section 4. Section 4 says no patent shall be granted if the invention relates to atomic energy as provided under Section 21 of the Atomic Energy Act 1962. So what this section says, it says that no patent shall be granted for an invention which is in the opinion of central government useful for or production or control, use, disposal of atomic energy, prospecting, mining, physical, chemical treatment, fabrication of prescribed substances or radioactive substances. So basically the Department of Atomic Energy notifies what substances will be considered prescribed substances and radioactive substances to attract the provisions of the law. Now we understand what is an invention and what are not patentable. And now the next requirement is sufficiency of disclosure. So basically, whatever is being claimed must be very sufficiently disclosed in the specification. So let's see. So the PCT system also requires that the whatever is being claimed should be described in such a manner that a person's claimed art could carry out the invention without any undue experimentation. So, the EPC European Convention law also says that it says something to the like the PCT, and it further says that it should provide a solution to the existing problem. It should be provided to design a solution to the existing problem, and the solution should also be provided. And US law says that it should be the invention should be described, its use should be described in such a clear and concise manner in the detailed description. So it doesn't require some undue experimentation. So basically, and let's see what our law says. Our law says that every complete specification itself fully and particularly describe the invention and also disclose the best method of carrying out the invention known to the applicant. And in case a biological material is being used, which could not be fully particularly described, or the best method could not be described, or it is not available in the public domain, then it has to be deposited in an international depository authority under the Budapest Treaty. India is a party to this Budapest Treaty, and the deposition has to be done before the filing of this application because the reference of the deposition is to be provided in the specification. And all available characteristics to identify that biological material and the name and address of the depository, date and accession number is to be provided in the specification, and the source and geographical origin of the biological material is also required to be mentioned. So why such an elaborative, stringent requirement for a biological material? So because it says that when the claimed invention is a compound, you can draw the structure, you can write down the process for preparation, you can write down the NMR by which you identify that this compound has this structure. In case it is a process, you can write down the process, what is the starting material, what are the intermediates, and what are the final product, what are the reagents, time, temperature, what are the variable parameters here. You can write everything. But in case of a biological material, it's a microorganism which is isolated from soil and no one knows about it because it is not available in the public domain. It is very difficult to understand even if you write down its ground staining and all, it will be very difficult for a person to describe the entire thing fully particularly in the detailed description. And even if he describes, it will be very difficult for the after the patent gets off patent, or if you are licensing your invention to someone, it will be very difficult to carry out the invention, because where is the biological material? How to obtain that biological material? The person is not going to isolate it from soil and identify that this is the biological material that is described in that particular patent application. To fulfill this requirement, it has to be deposited in a depository. So the requirement of this part of the specification is that there is a written whatever is claimed should be sufficiently disclosed, and disclosure should be written. In case of biological material, this written description requirement is fulfilled when the biological material is being deposited in a depository. So the public could access that biological material and carry out the invention. So this is a requirement of the sufficiency of disclosure. So how to determine the claim invention is sufficiently disclosed or not? So first step is to determine the scope of the claim invention. And the second step is to determine whether the specification commensurate to that scope, so that the subject matter of the invention could be carried out without any undue experimentation. So if there is an element of an undue experimentation is coming, and in that case, there is a lack of sufficiency of disclosure. So let's take an example to understand it. Here, the claimed invention is, let's say, this is a compound of Formula 1, and there are variables like R1, R2, R3, R4, R5 in this compound. And in the claim, it is defined that R1 could be phenyl, pyridyl, thiazole, thiolalkoxy, thiolalkyl, alkoxy, and methyl. R2 to R5 could be methyl, toluene, phenyl, pyridyl, anything. And this compound is a pharmaceutical compound that increase oxygen intake capacity of the blood. So this is the claimed invention. Now coming to the detailed description of the invention. So here, the detailed description of the invention should actually, in this case, is only describing or providing the details or providing the processes for preparing those compounds where R1 is phenyl. Let us focus on phenyl R1 only. Don't go to D2 to D5. So here the compounds are which are synthesized by the detailed description. All the compounds have phenyl at the R1 position, and there are no compounds with pyridine, thiazole, thiolalkyl, alkoxy in the R1 position. So in this case, the scope of the claim is much broader, and the disclosure of the claimed invention doesn't commensurate to that scope. So the person skilled in the art has to carry out undue experimentation to find out, first of all, to prepare those compounds where there is phenyl, pyridine, thiazole, thiolalkoxy at this particular R1 position. And then he has to identify, see that it has the same structure. Then he has to apply to or check whether it is actually showing this oxygen increasing property of the, it is increasing the oxygen intake property of blood. So, so a lot of undue experimentation is there. So there is a lack of sufficiency of disclosure. And when such claim comes, the patent office just remove those parts which are not supported by the detailed description, and only that part that is supported by the detailed description is granted. So in this case, there is a lack of sufficiency of disclosure. Okay, now let's move forward. So we basically understand what are the basic requirement or what are technical requirement or major essentials for a grant of a patent, which are considered during patent prosecution. And now let's move forward to a few other requirements like unity of invention. So section 10.5 says that claim of the complete specifications are related to one invention or a group of invention that is linked by a single inventive concept. So as you know, for one invention, one patent is granted. So for many invention, one patent is not granted. It has to be divided up. So let's take an example. If claim 1 is a compound AB, that is an antibiotic for treating bacterial infection. Compound claim 2 is a steroid for treating bacterial infection. The steroid is S. Claim 3 is a bioactive compound B for treating bacterial infection. Here, all of them are treating bacterial infections, but the antibiotic has a different structure, the steroid has a different structure, but the bioactive compound B has a different structure. They are structurally unrelated. Even though they are treating the bacterial infection, they are structurally unrelated, so there is a lack of unity. All these, if such an application is filed, it has to be divided out, and separate applications are to be filed for each and every one of these claims. But let's take an example here. If the claim invention is a compound of Formula 1, there is a process for preparing that compound of Formula 1, which comprises ABC, 3 steps. And there is an apparatus that is designed to carry out the process ABC in that apparatus. In this case, this compound of Formula 1, if it is novel and inventive, by the novelty and inventive step, or by the virtue of the novelty and inventive step of compound of Formula 1, all these 3 things, the compound, the process, the apparatus in which the process is to be carried out, they are linked by a single inventive concept. So this is a linking between them, and there is no lack of unity, and all the 3 could be granted in one patent. So in case there is a lack of unity, the patent office communicates it to the applicant, and the applicant has to divide out the invention. He can maintain one claim in the main or parent application, and file in the first case he has to file 2 different patent divisional application, in which in one he will be claiming the steroid, and then the second divisional application he will be claiming the compound B, the bioactive compound. So now let's move forward to briefly understand the opposition system. In the Indian patent system, there is a provision of pre-grant opposition as well as post-grant opposition. So pre-grant opposition can be filed by any person. Previously, it was without fee. Now the fee has been introduced by the recent amendment. So it can be filed by any person before the grant of a patent. So the period in which the pre-grant opposition is filed is after publication till the date of grant. If the opposition is filed, it is called the pre-grant opposition. In case the application is granted and the grant is published, it is now open for 1 year. It remains open for post-grant opposition. So if a person, in this case, it cannot be filed by any person. It has to be filed by the person interested. The person interested means he is doing research in that, or he is an industry manufacturing something, and the grant of the patent will hamper his business or something. So he is the person interested. So he has to establish his locus standi. He has to say what activity he is actually involved in, and how this patent is going to be hampering his own business or own interest. So, and it is to be filed by this person within 1 year from the date of publication of the grant. And the grounds are more or less the same. The grounds are, in case the invention is wrongfully obtained and filed and obtained. In case the priority is it is published somewhere before the priority date, so if there is a lack of unity, or it is claimed in a patent application which may be published after the filing of this application, but the claiming is earlier, so it is prior claim. There is a prior claiming component here. So it is being publicly worked or used, or it is obvious or doesn't involve inventive step over the prior art document cited, and or it is a non-patentable invention. It means it is novel, inventable, industrially applicable, but it falls within the provisions of section 3 and 4, or whatever is claimed is not sufficiently disclosed in the claim in the specification, or the foreign filing information is not provided under section 8. Or this is a conventional application, and it is not filed actually within 12 months. So some data tampering is done and it is not filed within 12 months. These are the grounds for the opposition. So opposition has to prove it. And next, if it is wrong, the source and geographical origin is not mentioned at all, or if it is mentioned, if it is wrongfully mentioned, then also it is a ground for opposition. And if the invention is a traditional knowledge, then also it is a ground for opposition. So grounds for opposition for pre and post grant oppositions are the same, but the situation in which the pre and post grant opposition are filed are different. So in case of a pre-grant opposition is filed, it is taken up during the examination, and the examination and opposition are taken up and simultaneously decided whether the patent is to be granted or refused. But once a patent is granted, post-grant opposition is filed, and once a post-grant opposition is filed, a body of opposition body is constituted in the patent office, comprising officials of the office. The person who has examined the case will not be a party to that member of the committee, and they will decide, they will see what are the grounds of opposition, and once the opposition is filed, the applicant will reply to that. In the post-grant case, the opponent will reply to that, and what are the submissions of the applicant or the patentee, and what are the further documents submitted by the opposition, and what are the further replies submitted by the patentee or the applicant. And by studying that, the opposition board will decide whether actually there is a any of the grounds stands actually, and the patent could be revoked or may not be granted in case of pre-grant opposition. And this body or this board give their opinion to the hearing controller, and the controller hears both the party, the applicant, the patentee, as well as the opponent, and based on the ground, the application may be the patent may be allowed and the opposition may be dismissed, or the patent may be revoked and the opposition is allowed. So this is the outcome of that. And basically, so I want to conclude here. I think I have been able to describe how the patents applications are filed, what are the basic requirements for grant of a patent, particularly novelty, inventive step, industrial applicability, what are non-patentable disclosures, and how much disclosure requirement is there in case of a claimed invention. If it is a very broad invention, your disclosure is very low, very less, then your invention may lose some part of the claims. You may lose some part of the claims. So all these all these things are communicated in the first examination report, to which the applicant has to reply. He may amend the claims, amend the specification, or may provide proper justification. He may need to narrow down the claims if the claim is so broad and there is a very specific prior art there. To avoid the prior art, he may amend the claim into a different format, or he may remove a part of the claim. So the applicant has to amend the claims to justify novelty, inventive step, and make it reward it to make it a patentable invention in India. And after that, the patent is either granted, or after giving a hearing, it may further be granted or may also be refused. So I want to conclude here, and I want this session to be a bit interactive. I think there must be some questions. In case I'll be happy and very glad to answer. So I'm stopping sharing. So in case there are some some questions, I cannot see the chat box, but in case there are some questions, I will be very glad to answer.
Thank you. Thank you for your demonstration.
Are there some questions? Actually, I cannot see questions here, but it is always good to make the session interactive so that at least.
Ma'am, there is a question where to concentrate in paper 2 examiner.
Paper?
Bhuvana is asking where to concentrate in paper 2 exam.
Paper 2 exam of the patent agent examination, right?
Yes, ma'am.
So paper 2 is, I think, the descriptive part. In the paper 1, I think, is the MCQ. In the descriptive part, you first of all you have to go through all the sections which are generally which will be used at the time of examination, or at the time of replying to a particular thing, and also to other sections as well. You will be given certain circumstances, like in case depending upon your field, you can choose the questions, and you will be given a particular circumstance, and you will be asked that you are the patent agent, and this is the situation of your client. How you will prepare to file a patent application, or something has been happening with the applicant, and how you will provide your IP inputs there. Or there is a situation, in what way you will draft the claims, what will be your first type of claiming. So in that way, a situation could be given. So please go through the 10 years question, and the 10-year questions are very helpful in understanding the way questions are asked, and go through all the sections actually of the Patent Act, and prepare for some questions in your specific field, so that You can answer. In case you are in the field of chemistry, you can choose a chemistry question. If you are an engineer, you can choose a mechanical or engineering case and answer that. But the situation is there in that, and you will be asked to draft a set of claims, or you will be asked to draft the entire specification, sometimes not the full but something indicative. So on that basis you can prepare for the second paper.
Thank you, ma'am. Thank you. No more questions, ma'am. Thank you, Dr. Lipika, for your enlightening and knowledgeable speech on patent filling and prosecution. Your words have provided us with a deeper understanding of the importance of these concepts in academic and research. We're truly grateful for your valuable contribution to our patent development program. Thank you.
Thank
Now,
you.
as the end of this session, it's my pleasure to invite Mrs. Tricia Darwin, Assistant Professor, Department of IT, to deliver the vote of thanks.
Good afternoon, everyone. On behalf of the organizers, I would like to express our sincere gratitude to all of you for attending today's event. First, I would like to thank our esteemed speaker, Dr. Lipika Patnaik, Senior Principal Scientist at CSIR IPU, New Delhi, for sharing her valuable insights and expertise on the topic of patent filing and prosecution. Your session was both informative and inspiring, and we are grateful for your contribution to the success of this event. I could also like to extend our heartfelt appreciation to our Honorable President, Engineer ACS Arun Kumar, for his support and guidance. Your leadership has been instrumental in shaping the success of our department and this event. Our sincere thanks go to our Vice Chancellor, Dr. S. Geeta Lakshmi, Registrar Dr. C.B. Palanivel, Additional Registrar Dr. V. Cyril Raj, Advisor Dr. Mehta, and Dean ENT Dr. Etiraj for their vision and encouragement. Your guidance has been invaluable in bringing this event a great success. My heartfelt gratitude goes to my department head, Dr. N. Kanya, and my colleagues who have worked behind the scenes to ensure the smooth running of this event. Your dedication and hard work are truly commendable. Finally, I would like to thank all the participants for your active participation. Your presence had made this event a truly interactive and enriching experience. Once again, thank you everyone who has contributed to the success of today's event. Thank you.
Thank you, Tricia. Thank you to all the participants for your invaluable contributions and enduring support. Participants, please fill the attendance and feedback link without file with CP shared. The link will be enabled in the next 20 minutes. Thank you all.
Faculty of Engineering and Technology, Mechanical Engineering, Electronic and Communication Engineering, Electrical and Electronic Engineering, Computer Science and Engineering, Electronic and Communication Engineering, Biotechnology,
Rajajeshwari Medical College and Hospital is a dynamic, reputed, highly acclaimed institution situated in the serene 25-acre campus in southwest Bangalore. The college has state-of-the-art research laboratory with qualified and trained personnel. The fully modular operation theaters in the hospital are equipped with the most advanced systems and devices. Highly experienced, top-notch surgeons undertake complex surgeries in a spectrum of specialties, thus helping the patients to get the best clinical care.
ACS Medical College and Hospital, Chennai,
This spacious, well-ventilated and open-class design provides space for sessions for the doctors, students, staffs and nurses, and technicians.
Faculty of Medicine, Sri Lalitambigai Medical College and Hospital,
The hospital has a wide range of round-the-clock laboratory infrastructure with skilled staff providing prompt service to the patients. The ICUs constitute the pride of the country. The well-stocked pharmacy in the hospital works around the clock.
Faculty of Dental Surgery, Thai Mogambique Dental College and Hospital. Faculty Faculty of Arts and Commerce. Faculty of Humanities and Sciences. Faculty of Law. Faculty of Physiotherapy.
Skill-staffed physiotherapy department helps in the rehabilitation process.
Faculty of Pharmacy.
The well-stocked pharmacy in the hospital works around the clock.
Faculty of Nursing. Computer Applications. Faculty of Hotel Management, de novo courses. Faculty of Education. General Facilities.
Library is a treasure trove of knowledge. Fully equipped ambulance services, multi-cuisine nutritional cafeteria for students and the staff, gym facilities, separate sessions for men and women, comes with all exercise equipment, a spectacular cricket ground, and separate swimming pools for boys and girls.
Few of our events in lineup. Degrees are awarded to the graduates on the convocation day. Dr.M.G.R. University, providing education with moral and social values to bring out the youth with character and humility beyond compare. Following the footsteps of a phenomenon, Bharatna, Dr. M.G. Ramachandran, former Chief Minister of Tamil Nadu, for meaningful progress and better tomorrow.